All right, home stretch. Social media sites. So, as I mentioned, there's a bunch of sites that deal with SR&ED issues in Canada alone. The three main ones are called SR&ED Canada, which has 1,500 roughly members. The Canadian Advanced Technology Association's group, which has 1,200 members. And there's one called the R&D Tax Credit Forum, which is actually international. But it's funny that the issues are almost identical when you look at them, except you got people coming from Europe and the United States and talking about all the same issues we talk about here. And I say, it's really just the same problems everywhere. Microcosm. These groups have become very, very active lately. And there's been increasing comments on two main themes. The first is inconsistency of the program. And there's hundreds of comments like this from very senior practitioners. I'm always shocked when I go in there and see who's complaining, and people that really, in my view, understand the program and practice well are upset with the program, and that really alarms me. So some of the comments are right here, copy verbatim. Looks like the strength of the claim does not matter to CRA. Sometimes I have a feeling CRA is putting all the claims in a big table and randomly selects 5% that will be rejected. I mean, you can go in and look, but these are senior practitioners. These aren't people that are new to the SR&ED program. These are people who've practiced, done hundreds, maybe thousands of claims, and they're saying it wasn't always like this. It's like this now, and this is a new thing. It's a problem. The program is broken in parts. Okay? They say, I've seen some very strong claims being rejected and some very weak ones being approved. I can concur with that. I see that all the time, to the point where I've heard senior practitioners tell me, I don't know what SR&ED is anymore. And these are guys who really, I thought could teach the course, and they're saying there's no rules anymore. The CRA is making up its own rules. They're doing whatever they want in certain isolated situations. Another one. We're hearing that files under audit are being steamrolled to an assessment, and the request for supporting documentation goes beyond reason and reflects new expectations beyond what we have previously experienced. So, whether you've had similar incidences or not, these seem to be common themes. And it's not, like I say, if it was just one practitioner, you could throw it out. But when it's dozens of practitioners saying the same things over and right across Canada, I'm starting to really get alarmed, especially when I see situations that parallel exactly the concerns that they're raising. Someone says that several years ago, the Harper government said it was concerned by the increasing size of the program, and now they seem to be making it smaller for whatever reasons. Again, the stats tend to support that money is being shifted from the SR&ED program. Somewhere to the tune of $500,000 to $1 million has been shifted over the last couple of years into wherever, direct funding or other sources. Okay? The other big one is technological advancement. So people are commenting on CRA saying there's no technological advancement. And that's period, full stop. So, quote, there's a trend in the CRA with the mistaken belief that standard practice means experimenting with practices and methods known to you. In that case, there's no SR&ED ever, because you're an engineer and you use engineering science. They're saying, well, if you're an engineer using engineering science, you can't make any advancement. Which is kind of a silly argument or juxtaposition. Our position is if it's standard practice, then why would you do experimentation? Kind of a good point. But again, these arguments are no longer working on certain CRA officials. Again, seems like a problem. All right, on the advancement, there seems to be a discrepancy between CRA's definition and those in common research papers in the field of what, in fact, constitutes an IT technology when using that as a basis for whether the technology was advanced in the project. So basically, they're saying that if you're claiming advancement in software IT, it's become very, very hard. That there's really no consensus on what industry would say is an advancement versus what CRA would accept as an advancement. I've personally seen some situations like that, so I think there's going to be some real interesting software cases coming into court soon. Maybe get some good precedents on that. Okay, so off from the social media, what practitioners like ourselves are saying, kind of in a semi-private forum, to Globe and Mail. Wrote another article here. So they're basically saying that based on this case, it's called immunovaccine, they say, quote, For years, many companies have been billing the taxpayer twice, when they do the R&D once and then via tax credits. And then again, twice. When they do the R&D once via tax credits and then again through direct assistance for the same work, typically through repayable loans or other kinds of contributions. And now they're saying that this tax court case is threatening to turn the whole thing upside down. And I'm saying government assistance has been defined in the Income Tax Act since I started practicing, reading it, 1993, 94. It hasn't changed. If you get a forgivable loan in relation to SR&ED, that's government assistance. It decreases it, and if you repay the loan, then you can get your credits back. And it's always been that way. There's no change in the law. This client just didn't know. They made a mistake. And they went to court, and the court was clear. No, you lose. The law is crystal clear. There's no change. There's no turning anything upside down. And yet, the Globe and Mail is saying that there's a huge change or a shift that's turning things upside down. I'm saying they took an example of a practitioner who didn't understand the law and filled out the return improperly, went to court and lost because the law is crystal clear. There's no problem, and companies aren't doing this. The law's always been clear. So again, the problem is, I read this and I know this is all wrong. Like everything they're saying is completely wrong. There's no change in the law. The law's always been the same. This is an isolated incident that they're extrapolating into a big problem. So I think this is misleading because people who read the Globe and Mail and aren't understanding of the SR&ED will believe that this is the case, and again, that this money is being mismanaged. And again, I don't know what to do with these guys. I have to write a long letter to the editor, but I don't know if that's going to do anything. They seem intent on publishing these kinds of statements, which almost makes me think there's more of a political agenda to what they're writing than anything factual. So I don't really know the purpose of these articles, but they're not news. They're propaganda as far as I'm concerned, and they're very misleading. Anyways, what to do about it? Your guess is as good as mine. Okay, some other issues that weren't cited in my newsletters, but that people have brought up. So I'm going to get to one of yours, Harvey. September 19th, Bill Curry writes an article in the Globe and Mail saying that notices went out to more than 100 staff who handled taxpayer appeals of CRA decisions. There's going to be a new focus on small or medium-sized business. And basically, the question here is, how come CRA told us years ago that they had a big division to review all these objections? I was told numerous, 14 or 15 full-time people who are reviewing all the SR&ED objections. And yet there's still 600 of them. And there was 600 of them a year ago, and there was 600 of them 2 years ago. So they haven't done a single, 15 people haven't cleared one file out of 600 in 2 years. I don't believe that really there's a strong emphasis on really trying to settle this or solve anything there, as much as just delay it as long as possible so that people stop claiming. And now I hear that they're going to lay these people off or redistribute them to other areas. I don't know if there's any hope for the CRA objection process. I'm really hoping, kind of what you're saying, is there a shift to it? I'd say it's quite the opposite, that the shift seems to be away from dealing with these 600 files that are in objections for over a year now, and probably leaving them for another year or two. So again, I'm worried about what this means, but I'm also happy that CRA objections is really just an interim step, and you always have the right to go to tax court. So again, if the objection process is broken and it can't handle the problem, you really have no alternative but to go either the general procedure and formal appeal or to give up. Those are really your options. CRA just released a video series, September 9th. It's 4 videos about what is SR&ED. The first thing I found is when I went to do them, they don't use YouTube or whatever. So, I mean, I have high-speed internet, but when I would play them, they would chop. They would play for 10 seconds and then wait 15 seconds and play for 10 seconds and then buffer for 20. So it was really hard. I had to watch them like 3 or 4 times to even figure out what was going on. That a 2-minute video actually took me 12 minutes to watch at the end of the day. But they basically provide a very generic overview of the program. What's cool is they have a transcript of what they say in each of them, so you can go in. The one that I find is most entertaining is obviously the one on what works eligible. How to calculate the credits and whatever are pretty much what you'd expect. I took the transcript and I copied some of the comments out of it, which makes the CRA seem very reasonable. I find it entertaining because I I read these comments, and then I look at what some of the CRA reviewers are saying on files, and I laugh. I'm like, I got to get them to read this. So they say, quote, so how do you know if you've achieved a technological advancement? An easy way is to ask yourself, what technological uncertainties did you encounter when you tried to develop the product or process? Fair enough question. It says, technological uncertainties are barriers that prevent you from achieving your goals. The knowledge that you gain in overcoming these barriers is a technological advancement. All right, again, fair enough. Nice layman's terms. It's the next comment that really hits home. They say, quote, in a nutshell, if you're doing a systematic investigation or search by experiment or analysis to advance science or technology or where it qualifies. It's that simple. So anyways, I'm dying to, in some of my rebuttals, I'm going to be using this quote. It's going to be one of the most quoted ones. But nonetheless, interesting kind of video. It shows, in my opinion, a spirit to at least do things the right way. Like at a high level, someone seems to have the right idea. I'm saying that this is a great vision. I'm just not sure in practice that at the front lines it's being explained properly or being mobilized properly. This is a chart that I pulled, or someone sent to me, an engineer, and I see this a lot, this argument. And this chart kind of summed it up. I thought this is a pretty good summary of the problem between what they call the scientific method and the engineering method. And the engineers say, look, we do engineering, but we don't follow we follow a loose scientific method, right? That ours are more results driven, that really we do background research, we get a question or a problem. Instead of creating a hypothesis, we talk about objectives. What do we need? The requirements. Then we brainstorm. Instead of defining standard practice, we look at ideas. This part here would often, brainstorming would include, here's what we did before, here's something similar. So I would argue that the standard practice definition would be maybe part of this or a subset of that. But then they just prototype and redevelop. So based on results, make design changes, review and test again. Communicate results, as opposed to here, communicate the conclusions. And that's really the difference, that the engineering issues tend to focus on, hey, it worked, we're good, client's happy, let's go on to the next thing. And all you've got to do to close the loop, I think, to take the engineering method and make it applicable to scientific, is ask yourself a little bit more about why. Why did something work in here? Why did that solution work better than the other? So I think the two are completely complementary, but you want to just tweak the engineering method, the quick and dirty experiments, to ask the people real time while they're doing the work, what were you thinking? How did this relate to some variables? And if that happens, they're really the same process. Okay? The engineering method becomes harder to document a year after the fact because it's all in the person's head and it isn't always documented as well on paper. Okay? And that's really the main difference. Okay? I think I talked about this already, that at the Tax Court of Canada level, the informal appeal versus the general appeal appears to be the optimal way to address any disputes if it's not handled at the objection process for all the reasons that we talked about. Okay? The general procedure is generally going to cost you upfront cash, $40,000 or more to hire you have to use a tax litigator, all kinds of court procedures. You're going to wait 3 to 5 years, in which case all your SRED claims for the client are going to be held for 3 years. You're going to lose that client for sure, I'd say, unless you really got them in good. So I'd say for practical purposes, this is really your only solution. There's a $100 application fee. You can represent the client, or the client can represent themselves on. If it's a technical issue, I'd want to have the head of R&D or someone who understands the technology. And if it's interpretation of the law or the act, then yourself or someone who understands the act can be there. Okay? It's quick. And the limits have gone up to $25,000. Better yet, you've got a publicly published document that you can use for other purposes. Sorry, Harvey, were you going to ask?
I was going to just make the comment that the rules of evidence in the formal procedure are almost the same as the rules of evidence for a general procedure. And that, to somebody who hasn't done this before or doesn't have the experience, can be they can be led astray because they don't understand what the courts will accept and what the courts won't accept.
So the comment there is that in an informal procedure, there's still requirements and formal requirements that have to be followed. There's a whole listing of what those are. So Harvey's comment is, or advice I guess would be, you want to familiarize yourself with those procedures before you go to court rather than learning it the hard way. As an example, the Murray-Arlen case, that their representative, and I talked to her, I told her you should go informal appeal, but she didn't realize that when you go, you have to have all your evidence there. And they kind of came in empty-handed thinking they were going to talk about stuff, and that was it. You lost. You don't get a second chance there. So you really want your ducks in order. As you said, the evidence requirement is simple. Bring everything you're going to need on the court date because you're not going to get a second chance is my rule of thumb on that. Yes?
Go back to your prior slide.
Yeah.
That last bullet, provided legal precedent, that's applicable just to the claims themselves?
No, you have a published... You could talk to people. I mean, tax litigation will tell you, oh, an informal appeal doesn't have the weight of a general procedure. I disagree. I mean, the judges who rule on informal procedures are the same tax court judges that rule on, like, look at the names. It's all the same guys. And they talk about that section of the Act and why it applies. The only difference is the amount in dispute. They follow the same process and provide the same. They don't care if it's $1 million or $10,000. They're going to apply the law, and they're going to apply the law in a way that they feel is fair and judicious. The amount's really a secondary issue. When you're dealing with technical eligibility or something, it's either in or it's out, and that's what they're going to focus on, which is why I think that informal appeal is a good option. The general procedure is good if you have a very large client with deep pockets who's really motivated, but very often those clients, even if they can afford it, I find they don't want their public affairs publicized. So even though they could do it, they don't want to do it. So I mean, you're caught in a catch-22. It's usually the smaller claimant that's really upset and is more willing to go there to see justice than the big performer who's saying, well, justice is kind of a moving object, and is more looking at the bottom line. Yes?
The informal procedure, the limit is $25,000, but can you also claim your legal costs?
Oh, you may actually be able to claim costs, but usually it's not your full cost. It's limited to some trivial amounts per year. Yes?
One clarification there. Under the informal procedure, the judgment is not considered to be jurisprudence. It can be, Justice Bowman says, it can be used by the judge if they think it's well argued and if the previous justice has reached the right conclusion. Whereas under the formal procedure, it automatically becomes jurisprudence.
These are like the level of tax court arguments, and I'm not disagreeing with it, but I'm saying from a practical purpose, there's not that many tax court judges, and they all talk amongst each other. And once they make a decision, the decision is based on the facts, evidence, and how they interpret the law. And the amount is really a completely secondary issue. They want to apply the law judiciously, whether it's $1 or $10 million. And they do consider that an effect. But I would say that the small claims is still a good way to get a publicly available document that's approved by a judge. I mean, it says you either follow the law or you didn't. So to me, the real difference is just the amounts in question, not only on what you could get, but also what you have to pay to get it, and the amount of time that it takes. And really, to get practical about it, if I got a client with 6 projects, a $100,000 or a $200,000 claim that gets denied, and I only got to go for $40,000, I'm going to pick the best project. I only need to pick $25,000 worth. I'm going to pick my star project, and maybe some of my other ones were weaker. So it really puts a lot of the advantage in the claimant's hands as opposed to having to defend all 6 projects, and maybe some of them are weaker at the end of the day, and now you're going to waste time on that. So I mean, there's no right or wrong. I think both have advantages and disadvantages. Yes, Bert?
Is it possible to split the projects so that you can claim each one for informal procedure?
No, because it's by taxation year.
It's by taxation year.
Yeah. Not only that, I mean, you want to be careful with the informal procedure. If you read the Tax Act, or Tax Court Act, I think it's called, which talks about the rules for the tax court as opposed to the tax rules, they say that for informal procedures, it's not applicable to an issue that covers multiple taxation years. So if I have a project that's 3 years, I can't just say, oh, let's go for 2010, and then whatever happens applies to 2011, 2012, technically. But most CRA assistant directors, when I talk to them and we disagree, I say, why don't I go to court for 1 year and see what happens, and then you can decide on the assessment for the other. In other words, they're saying, hey, if you beat me in court, you win. If I win in court, you lose all the years. So all the years are on the table, but we're not filing an actual formal appeal. Now, whether CRA knows enough to come back and use the tax court rules, I would say probably not, because I've never met anyone in CRA who even understands how to read the Income Tax Act. Never mind tax court procedures. I mean, it's just not going to happen. Dominic, I guess, didn't make it. I'm not sure what happened to him. Yes, Mike?
Yeah, so for the, I say, the Ontario portion or the Quebec portion of the R&D tax credit, you can actually file that separate? That's not included in 25 provision?
No. What happens is, when you go to tax court, the limit is $25,000 federally, and if you get the $25,000 federally, that's your CRA credit. If the province that you did the work in has additional credits, you would get whatever those credits are on the $25,000 of qualified expenditures, if you follow me through. No, well, you would have to file the return on time.
The return was unfiled, but by the time you actually went through the informal procedure...
Oh, yeah, no. As long as you file the return on time, I mean, the courts will take as long as they have to make it. I mean, you can see cases now that are coming out on dealing with 2004 taxation years, right? We're in 2014, and once they make a judgment, it's in. So once it goes to court, there's the statute barred thing doesn't really apply so much, or 18-month rule or stuff like that. All right. Oh, can you knock me down one? Okay, some of the new changes that came into effect, this is probably nothing new, just a recap on that one. Capital coming out. All right, we've got the international definition of R&D there for whatever reasons. Oh, just one thing I like to point out, because I see this mixed up a lot on claims that I review, is the issue of YMPE, yearly maximum pensionable earnings. And this gets confused a lot. And when you're dealing with a specified employee, so an employee who owns 10% or more of any class of stock of the corporation, or anyone related to them by blood, marriage, or adoption. So you want to be careful here, like the owner's granddaughter who works there and could get caught under these rules because they're related. They have certain limits, and the limits are both for wages and for something called the salary base that they then multiply by anywhere from 55 to 65% to get the proxy amount, depending on what year you're dealing with. I see a lot of people confuse this or misunderstand the implications of it. And really, what these rules do when you understand them are they're pretty fair. They're saying, as an owner-manager, I can pay myself as much as I want. I can even bonus myself $10 million at the end of the year and deduct it, and as long as I pay the personal taxes, CRA is not going to challenge me. They have an administrative provision that, hey, they're happy because I'm paying 46% tax on $10 million. They got no problem with that. I want to encourage that. But what they're saying is, you can't, as a specified employee, you can't get any credits on a bonus, tax credits on a bonus. Bonus is not allowed. So you want to, instead of bonusing down to the $500,000 small business limit or something, I'm saying, when you're doing SRED, you got to be more you have to be a year ahead. You have to salary down. Say, hey, you made a lot of money last year and you're bonusing. You think you'll make that much money again? And if so, maybe we should bump your salary up rather than bonusing you. You pay the exact same personal tax at the end of the year, but one's 100% eligible for SRED and one's not eligible for SR&ED. Pretty easy number to justify. What I find people miss is that this limit is 5 times YMP. So for 2013, the first $255,000 I pay myself related to SR&ED, I get full credits on. Anything over that, I still get to deduct as an expense, but I don't earn credits anymore. And that's really what's missed. So that as an advisor, you want to ask the person, what do you expect your income to be next year? Do we have to bonus out? And if so, let's jack your salary up during the year so that we can get credits on all that amount. Assuming they're more than 25% SR&D, it's generally going to pay off. If they're very small R&D, then don't worry about it. Okay? The other thing that that people miss is that the limit is 5 times YMPE for wages, but it's only 2.5 times YMPE for the salary base to calculate that amount. I've seen people mix that up and think that 2.5 times YMPE applies to the other limit and things like that. And the form's not really that clear on how to do it and why to do it. So once you understand this, I think it's pretty clear. But like I said, it's something that I see mixed up a lot. So that's basically the table that I use to flesh it out. And that'll wrap it up, unless anyone else has other questions or issues they want to discuss.